Webinar, looking at the latest developments on Brexit. For this webinar, I'm going to take you through a brief introduction and state of play before handing over to my colleague James First, FTA Head of Licensing Policy and Compliance Information, who will take you through the possible impact of Brexit on domestic road transport legislation, also looking at changes that might be planned at EU level. And at the end, I will be happy to take some questions. So first of all, before we start, some webinar house rules. Please keep your microphone and telephone muted to avoid any feedback. The webinar will be recorded, so you can always come back to it afterwards if you want to. The recording is going to be made available on the FTA website as of tomorrow. I'm very sorry, but we will not be able to deal with technical issues during the webinar. So if you do experience any technical issues that would prevent you from following it as you might otherwise wish, you can always go back to it because, as I said, it will be available on the website for you to watch at your convenience. If you have a question, of course, you're more than welcome to use the chat box to ask any questions you might have throughout the webinar. Any unanswered questions and answers will be available to view on the FTA website in the Brexit section afterwards. If we answer them, we might not necessarily include them because you would see the recording of our answer anyway. So just as a way of introduction, obviously, as we said before, the decision to leave the EU is going to affect all segments of the membership. Today we'll be looking specifically at those who operate at domestic level, and even if you don't operate internationally, even if you don't have any international operations, the impact of Brexit will be pretty significant. We have produced an ABC guide to Brexit to try to map out all of the key issues and ask some questions to both industry and government in order to start this discussion and this thinking process that will lead us to successful Brexit. We are organising regular Brexit webinars on a monthly basis to keep FTA members up to date with all the latest developments. And as I said, all the past webinars can be viewed on the FTA website whenever you want. So we had the referendum, and now what's next? Well, there are many unknowns, of course. The political landscape in other EU member states is one of them. There was a referendum in Italy just a few days ago, which has triggered a change of government. There will be elections next year in France, in the Netherlands, and in Germany as well later on. All of this will have an impact on the Brexit negotiations and the outcome, because essentially it will mean that the people we negotiate with might very well change during the course of next year. So this is obviously a great uncertainty to take into account in this process. The sequencing of negotiations is also something which is not entirely clear at present. We have heard several times from government that they wanted to take in parallel the discussions on the withdrawal agreement per se and on the future relationship with the EU. But there was a press conference that was given by the chief EU negotiator on behalf of the European Commission last week, and Mr. Barnier, for the very first time since his appointment, set out what he thought was going to be the negotiating process and what would be the priorities for the European Union. Interestingly, or worryingly, he explained that the negotiations that would take place as part of the Article 50 process would only be focusing on the withdrawal agreement per se. That is to say, all the administrative issues that would need to be resolved before the UK can formally leave the EU, including things like pensions for civil servants, contributions to EU funding programs, contributions to the EU budget, and so on and so on. And that this agreement would need to be completed by October 2018 in order to give enough time to the EU member states, the European Parliament and the UK government to ratify it so that it may enter into force by March 2019 at the latest, provided of course that the UK government triggers Article 50 by the end of March 2017. This will have quite likely a big impact on the timing, if this is really what's going to happen. And Mr. Barnier said that the negotiations on the future relationship, including the trade negotiations and the arrangements for road transport and so on, could only be negotiated and agreed once Brexit has effectively taken place. So we're hoping that this will not be the case. And if this was to be the case, there will be a good transitional arrangement in place. It's quite reassuring to hear the Treasurer say yesterday that this is something that government is seriously looking at. So we're hoping that indeed there won't be any sudden changes. However, and that's good news for you, there are some certainties. Nothing changes until the withdrawal agreement has been signed. So based on the government's timetable, nothing changes until March 2019. And meanwhile, all the EU rules and regulations will remain in place at least until the formal withdrawal of the UK from the EU. On this slide, you can see the FTA ABC guide to Brexit. I will not go into it in much detail because you can see and hear more about some of these points in previous webinars. Today we will mainly concentrate on domestic legislation. So on domestic legislation, what we know at this stage is that government wishes to introduce the so-called Great Repeal Bill that will effectively repeal the European Communities Act of 1972. The idea with this bill is that it would basically take all of EU legislation that currently applies in the UK and transpose it into UK law, so that on the day of Brexit, all EU rules are still the rules applying in the UK but become UK legislation. Parliament would then be able to decide, at their own pace of course, which EU rules should be kept, which EU rules should be amended, and which could disappear for the benefit of industry. Of course, the scope for change depends very much on the new single market deal. Depending on the type of arrangement we get, there might be more or less flexibility in regulatory terms, and that might also apply to domestic legislation. To give you an example, Norway, for instance, or Switzerland have to apply most of the EU rules that apply to road transport. Are we going to end up with a two-tier system for international transport with different rules in the UK and different rules in the EU on the long term as changes are introduced in EU legislation? Well, that's something else that we will have to consider very carefully, of course. And it's worth bearing in mind that some of the international rules that govern elements of international road transport are either not decided at EU level or also replicated in international arrangements, and that's very much the case for driver's hours limits, for instance, which are basically the same for the ATR agreement as they are under EU rules, and that would also be the case for dangerous goods for international transport. So I'm now going to hand over to my colleague James Firth, who's going to take you through the possible impact of Brexit on domestic road transport legislation. James, over to you.
Thank you, Pauline, and good afternoon, everyone. So following on from Pauline's introduction about how some of the processes of Brexit are expected to happen and the way in which the domestic legislation is going to be approached, I'm going to look through, I've chosen 7 key pieces of legislation to have a look at, and we're going to use those to just examine where there are some opportunities or potential threats that we could take advantage of when Brexit happens. So we've sort of been looking in very general terms about the process of how it will go ahead. So this sort of allows us to look in much more significant detail at how some of the changes that could possibly take place. Now, we've started the process of talking to members about what they might like to see once we have left the EU. What are as I said, the opportunities that we might be able to try and take. And we've done this through, there's been a member survey that we've undertaken. We've just completed our run of autumn seminars, the transport manager seminars, at which we were discussing with delegates there about the issues that they might like to change or scrap or keep as a result of Brexit. And of course, we're also discussing this in FTA's freight councils. The freight councils, of course, are where FTA's policy on matters are decided by members, and it's available for all members of FTA to attend your local freight council in order to be involved in the formation of FTA's policy. So we're going to start by looking at operator licensing. Now, with operator licensing, we got there first. We were involved in operator licensing long before the EU did. And indeed, many of the rules that we understand from operator licensing are in place as a result of the Goods Vehicle Licensing of Operators Act 1995. But there are a number of aspects that have been brought in by EU rules. The most recent changes were at the end of 2011. But many of the changes when they came in were in fact taken from the GB model of how we undertake operator licensing. So we often described it as the exporting of GB good practice to the rest of the EU. So the 2011 changes weren't that significant when they came, but some of the things that they did bring in, which were different, were the single international CPC exam. So now any new entrant into the occupation of transport manager has to take one exam which covers the syllabus of the national and the international CPC holder. That is in contrast to as previously, where everyone would take the national CPC, and then if they wanted to move into international operations, they would then take the international exam as well. It brought in the idea of most serious infringements, also described as the 7 deadly sins, which I think people tend to know most directly through the impact on OCRS, although DVSA has recently announced they're taking the most serious infringements out of OCRS as trigger indicators. But more importantly, the EU rules require that when an MSI is detected at the roadside, the traffic commissioner must find against the operator's repute unless they find a reason not to. And another aspect that the rules brought in 2011 was defining this idea of the external transport manager, or a consultant transport manager. So someone who isn't employed by the operator but is qualified with professional competence and is able to conduct that role. Now, the rules identified that and brought in restrictions, which meant that such individuals could only be responsible for no more than 50 vehicles across a maximum of four licenses. So those are the sorts of aspects that we could possibly look at changing. At the time, there was concern about the international CPC being about the single exam for all new entrants, and indeed it has meant that the training course for getting the CPC is now longer than it was before. And it's also been suggested by members in discussions that we've had that for international CPC holders, people who need to use it on an international license, the exam now is perhaps not as rigorous on international aspects as it was when it was a separate exam. We also have to bear in mind, while we are going through this process of Brexit, that life goes on in Brussels, and the European Union continue to bring out regulatory programs and legislative programs we are still, FTA is still fully involved in that, the DFT is still fully involved in that process, but it does throw up some interesting issues regarding precise timings about when any new laws may come in. And we'll talk about that in a little more detail in just a moment. But we are in the process right now of the Commission looking at possible further changes to operator licensing, or as it refers to it, access to the occupation. Those include looking to further refine the definition of establishment, how an operator is established in a member state. And also they do have the proposal that some or all of the aspects of operator licensing could be applied to vehicles below 3.5 tonnes. So those are aspects that we are fully engaged in. We're not just cutting and running now that we know we're leaving the EU. The other half of operator licensing, as far as the European Commission is concerned, is described as access to the market. And the most significant aspect there is on cabotage. Now, cabotage aims to create a balance between limiting how much foreign hauliers can compete in the domestic market, but at the same time understanding that vehicles that are on international journeys should have the opportunity to maximise use of those vehicles, and therefore allows some domestic movements to be undertaken either end of an international journey, either in or out of another member state. So the rules concerning that at the moment are that in the space of 7 days, an operator coming in to another country may, in addition to the international load they are moving, either in or out, they may undertake 3 further domestic movements within the member state. So really aiming to stop someone being able to create a business plan of, I'll go into another member state and carry out domestic movements there. Now, whether we would want, once we leave the EU, to tighten up on that and go to what you might call a more protectionist position to prevent any domestic movements being allowed, or the other end is liberalise that and allow more to be done, is a point that we can discuss. But this issue, I think, more than any of the others that we're going to talk about today, will be fundamentally linked to whatever trading agreement that we come to with the EU as a whole. And of course, if we decided to take a more protectionist approach, then we could be fairly certain that the EU might reciprocate that, and we'd want to consider whether that would be beneficial or not. Once again, they're also looking at making changes to this area, and so one of the proposals that they've come up with in order to attempt, they believe, to tighten up the approach to cabotage is that the 7-day limit would be reduced. I think they propose to go to 4 days, but with no maximum number of operations. We're not altogether happy with that as a proposal, and actually see it perhaps as a more of a liberalised approach. So now, driver's hours, and I think it's probably the key issue that people identify with the EU, because they're referred to as EU driver's hours. Apart from anything else, we might have to rethink the name of how we apply these rules. So obviously at the moment we have a 2-tier system where there are, and that's simply by way of what the EU has put in scope of the driver's hours rules, and everything that isn't in scope, domestic hours apply. And having considered them, just the EU driver's hours rules, the view from members is that they're just about right. They have to strike the right balance between making sure that the drivers are safe, that they don't, to try and mitigate the effects of fatigue on commercial vehicle drivers, whilst allowing operational flexibility, operational efficiency to be undertaken. So members are of the view that they're just about right, and actually don't make changes to them, because whenever changes are made, it just means they've got to go through retraining. There's more likely for mistakes to be made, and we just want some stability in the system. So the view is that we should be retaining this 2-tier system. And as Pauline described at the start, the proposal from government at the moment is that they will take all of the EU rules and simply take effectively a carbon copy of them and apply them in domestic rules. So that's fine if we don't want changes, but it's likely that the EU will make changes in the future, and when that happens, we will have to make a decision. Do we stay in step with the EU? Do we make the changes that they decide to make, or do we decide to allow them to deviate, which will mean that anyone who's on international operations will obviously have to operate by what would now be an international set of driver's hours rules. We would therefore have potentially a three-tier system, which we might just say, well, that's an added complexity that you have to decide to enter into if you want to enter into international haulage. That's a decision that will have to be made in the future, but that decision may come sooner than we expect, because similarly, the Commission has come forward with proposals to make amendments to EU driver's hours rules, and they've just finished the initial consultation on that. But with normal EU processes, it's probably unlikely that they would come into law before we exited the EU. But it remains to be seen exactly how long either of those two processes will take. So I'm going to explore that aspect in terms of timing a little bit more with the next topic, which is on the digital tachograph. Now, digital tachograph, the requirement to have a digital tachograph comes again through EU legislation. And indeed, there is new legislation which will bring a new tachograph, what they call the smart tachograph, into new vehicles. And that regulation is already in force. Regulation 165/2014, already in force. It came into force in the UK in the 2nd of March, but sorry, the 2nd of March 2016 this year. But it makes this, the statement, there's an article there which says that the new specification of tachographs will be installed in any new vehicle first registered 36 months after the law came into force. 36 months after the 2nd of March is, after the 2nd of March 16 is the 2nd of March 2019. Now this new specification includes that it will take a GPS location stamp at 3-hourly intervals in order to aid enforcement, and also similarly to aid enforcement, it will transmit to enforcement officers at the roadside without the vehicle having to stop if a serious infringement is detected, such as the card being removed while the vehicle is moving, in order to allow the enforcement officers to know to pull the vehicle over. So that's some of the things that will come in the 2nd of March 2019. As Pauline described, the timetable we have for Brexit at the moment from government is that they expect Article 50 to be triggered no later than the 31st of March 2017, next year, and that it is a 2-year process. So therefore, if we keep to that timetable, the latest we will be leaving the EU is the 31st of March 2019, and we have this requirement already in our laws to install tachographs, new tachographs in new vehicles just 29 days before that date. Now, as it happens, on the case of tachographs, we're broadly supportive of what the new specification looks like. So this isn't going to be too significant an issue, but there will be other issues. This illustrates there will be other issues where the law will change. It could be days before we're due to exit the EU. And as things stand at the moment, the position from government at the moment is anything that's in that position, it will be enshrined in domestic law in this carbon copy process. If you like. Also, of course, there's the possibility that Article 50 will be triggered before the 2nd of March, before the 31st of March next year. It could be, and if it is before the 2nd of March, then we will be in a situation where, at the point when we leave the EU, the rules regarding tachographs will be set in domestic law, but we won't have, there won't need to be the noticeable action until after we've left. Now, clearly, getting everyone ready to put the digital tachographs in new vehicles from 2019 will require a certain amount of preparation on everyone's part. So I think it illustrates that the government is going to have to make a statement or a decision about how they deal with these things where changes are coming in just before the Brexit date. One of the most contentious issues in EU rules is, of course, working time. We've had long-standing concerns about the impacts of working time, and particularly this idea of, well, where in our industry the drivers are significantly regulated already in terms of drivers' hours, does it have any particular impact? The rules are similar but different from EU drivers' hours rules, and it tends to create a bit of confusion there. So this is certainly an area where there may be opportunity for making changes, and indeed FTA has already made a proposal as part of this latest consultation that the Commission has undertaken, that we could incorporate the duty limit into the drivers' hours rules rather than having a separate working time regulation altogether. Then driver licensing is overseen by three key pieces of European legislation, the Driver Licensing Directives 1, 2 and 3. And they most famously, of course, brought us the pink photocard driving licence, which we all recognise now. The most recent one, the third directive, brought in two aspects of note. One is staged testing, and that means that you must take and pass your Category C licence before you are allowed to move on to your C+E, compared to how it was previously, where you could go straight to the C+E and take the test for all of them in one go. And the other thing that it stopped was where previously, if you took your car test, what we now call the Category B test, you would have entitlement up to 7.5 tonnes. So that's the C1 entitlement as it is now. That was retained in grandfather rights, but we are certainly getting reports from members of having difficulty in finding drivers for that 3.5 to 7.5 tonne region, which we put down to no longer having that option available. Possibly one of the most contentious issues, if not working time, is of course driver CPC. We might want to take the opportunity to review it. An awful lot of the aspects that people complain about or can have concerns about with driver CPC are in fact due to the way that the UK government has implemented it rather than from the directive, and there are diverse views on how it should possibly be changed, whether we get rid of it completely, should there be some aspects of mandatory content included, should there be a test at the end of the period of training, and should there be a rule preventing you from taking the same course twice, to try and prevent this issue of where we know that sometimes drivers are able to take the same course 5 times in order to comply. One aspect that we have had highlighted by members is the issue around timings, where training has to be delivered in a 7-hour block. We think that is certainly something that we could look at changing in the way that is delivered. But the final one there is the 3-in-1 card. So this would be with the intent that one pink card could hold the driving licence, the driver qualification card and the tachograph card all in one. There's already the possibility to have the driver CPC marked on the driving licence. The government chooses not to take that option up, but in the most recent changes on the tachograph, which we discussed earlier, that at that point prevented the tachograph card being combined with any of the other ones. So it might mean that once we're no longer constrained by that, we could have the opportunity to try and go for the 3-in-1 card. And my thought on that is it's something that's very tangible. But if a politician wanted to say, look, we've left the EU, look what we've done for industry, it's something that he can hold up and show the difference that he has made, which is certainly offers an opportunity. So that's been very quickly going through 7 key areas that will or could be impacted by Brexit. We will continue to discuss these, and as as we go through the process, start looking at the detail of each of these aspects. But through discussing in freight councils already, we think we've come up with 3 positions that we can start pursuing already, which I've mentioned. The first is that there should be some form of review of working time for mobile workers. The second is try and pursue this 3-in-1 driver card, and the third is to decouple the national and the international CPC exam. So that's what we are working on to take forward, and what we will be showing in our Brexit manifesto, which FTA will be producing in due course.
Thank you very much, James. I'm now going to ask you if you have any questions to please enter them into the chat box. We don't have very much time left, so we'll only be able to take 1 or 2, but any unanswered questions, and of course their answers, will be made available on the FTA website afterwards. It could be that your question box minimizes, in which case it might appear in the top right corner of your screen. So if this is the case, by clicking on it, it should expand, and you should be able to type your question. We have a quick question to James. Do you know which changes to occupation are considered by the European Commission?
The changes to access to the occupation. So this is the changes to operator licensing, as we prefer to recall it. I think I mentioned the 2 key aspects are the change to establishment and also the suggestion to apply it to vans. And I think on the establishment issue, this reflects the situation we find ourselves in, that we go further in some areas on operator licensing than the EU does. So we have aspects such as the requirement to specify all of the operating centres and to specify vehicles to those operating centres. That isn't a requirement of European law. And as a result, we would say we don't have a problem, a significant problem, with what the EU described as letterbox companies. So these are companies that are operating transport operations within a member state, but don't have a significant operational presence based in that member state. So they're looking at how they can tighten those rules up and how they can improve that. We have said to the European Commission, look, in the UK, we don't have a problem with this significantly, so why don't you look at what we're doing and see if that will solve the problem. The danger will be if they look at if they try to bring in measures which are different from what we're doing and decide to apply those, and that will create difficulties for us in having to make changes in operator licensing. And the other aspect was, as I said, the application of vans, and this is almost a throwaway comment. It's there as a proposal that some or all of the aspects of operator licensing should apply to vehicles below 3.5 tons. They don't say how far below 3.5 tons, and they don't say which aspects of it there are. As it stands, FTA is opposing those proposals, as we make the point that you can't bring in more regulation of that sector until there is significant and realistic enforcement. We think the key issue there is the lack of enforcement in the van sector, which we have raised as an issue and we believe needs to be addressed. But those are, I think, the key aspects that we pulled out of the proposals regarding the operator licensing, or access to the occupation, as they like to call it in the EU.
Thank you, James. And for your information, these proposals should be published by the Commission in spring of next year, and we're thinking probably around April or May at the earliest. I see that there are some questions about driver's hours rules and how they would apply to international transport. In the interest of time, I would point you in the direction of the August webinar of FTA that dealt specifically with this issue, and the issue of AETR rules, in fact, which are like a carbon copy of the driver's hours rules. We will not be able to take more questions now, but if you have any questions, please feel free to answer them, and we'll try and provide our answers and make them available on the website. Meanwhile, I would like to let you know that we will continue this exercise of the monthly webinars. We have dates already for the next two ones, the 13th of January and the 14th of February. And my understanding is that you will be able to register as of tomorrow. So a link should be added on the Brexit section of the FTA website for these webinars as of tomorrow. For any more information on the implications of Brexit and logistics, please visit our website, look at the Brexit section. We'll try to put more news and information on there. Please feel free to, of course, attend our Freight Council meetings, which are going to start in the coming weeks and days. Join the conversation on Twitter, Facebook, and if you have any questions, don't hesitate to ask them. We'll be very happy to help as far as we can. So that's it for me. Thank you very much for joining us today. And as I said, if you have any questions, don't hesitate to ask.